Hello, my name is Ryan Kershaw, and today I will explain US safe harbors and how they impacted the court's decision in Perfect 10 v. CCBILL. In 1998, the United States established the Digital Millennium Copyright Act. This came about due to two opposing sides, internet service providers and copyright owners, wishing for further protection due to the rise of the internet. This led to US Congress establishing four safe harbors provided in Section 512 of the DMCA. Falling within any one of the safe harbors significantly diminishes copyright liability. The case resides around an adult website, perfect10.com, who has created around 5,000 images of models and holds registered US copyrights for the images. CWIE provides web hosting and related connectivity services, while CBILL allows consumers to pay for subscriptions by way of credit card or check. The case was appealed to the United States Court of Appeals for the Ninth Circuit. In assessing the appeal, the courts applied Section 512 and the relevant safe harbors. Firstly, to be eligible for any of the safe harbors, service providers must establish and reasonably implement a policy for dealing with repeat offenders. This is not defined, but if a company terminates the accounts of blatant and repeat copyright infringers, the implementation is reasonable. The original district court, along with the Court of Appeal, agreed that CCBILL and CWIE had a reasonable implementation policy, as the vast majority of webmasters were recorded in the DCMA log, allowing CCBILL to track repeat offenders. This distinguished it from the past cases of Ellison and Aimster, who failed to record any information about repeat offenders. Additionally, service providers do not need to police their users for infringements. Perfect 10 failed to give sufficient notice to CBILL and CWIE as they failed to act in accordance with Section 512, subsection C3. Perfect 10 argued notice was given over the course of 3 different documents. The court stated allowing a copyright holder to cobble together adequate notice from separately defective notices unduly burdens service providers. Therefore, Perfect 10 did not raise a genuine issue of material fact that CBILL and CWIE failed to implement a repeat offender policy per Section 512, subsections I-1A. It was held by the court that CCBILL met the requirements of Section 512, subsections K-1A, through the connection services it provides to clients for billing services. Perfect 10's argument that as this connection service was not transporting the infringing material was therefore invalid was rejected by the court. However, the court could not determine whether this allowed CCBILL to hold the role of service provider or simply be a transient holder. As such, this safe harbor was not met on the current facts. CCBILL also did not meet the criteria to be classified as providing information location tools. Once users had paid for the website, a hyperlink was displayed allowing users to locate the client website. However, Perfect 10 does not argue that the copyright is breached by the use of the hyperlink. Additionally, the majority of CCBILL's services remain outside the safe harbor, which would not provide blanket immunity for the rest of CCBILL's activities. Perfect 10 argued that CCBILL does not meet the requirement of Section 512C as it receives monetary benefit from infringing content, contrary to Section 512, subsection C1b. It was decided by the court that financial benefit should mean that the infringing content should be the main draw for users, and not just an added benefit. The court decided that evidence submitted by Perfect 10 was insufficient to indicate such a draw as required by the case of Ellison. It is also legislative history that a one-time flat sign-up rate does not constitute a financial benefit from infringing activity. Therefore, CWIE and CCBILL are capable of relying on the safe harbor. The safe harbor of system catching was not applied on the current facts. Therefore, as CCBILL and CWIE fall within one safe harbor, they are protected from monetary relief, although injunctive relief in the form of removing the copyright material still stands. Thank you very much.